All right, good morning, everybody. Before you have your seats, let's let our bailiff Jacob lead us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Thank you.
Good morning. Hope everybody's doing well this morning. It's so good to see you. My name is Tim Godwin. I'm the current president of the Escambia County Bar. Welcome to our Law Day program. Specifically, we'd like to welcome high school seniors from Cornerstone, Flomaton High School, W.S. Neal High School, and T.R. Miller High School. This is our annual Law Day program. The last 2 years have been difficult for our program because of the pandemic. 2 years ago, seniors were not able to participate at all due to the pandemic. Last year, we had a reduced number of seniors who participated, particularly the ones who were selected to be on the jury, and the rest of the seniors were able to watch the program on Flomaton's YouTube channel from their schools. So welcome. It's great to see the courthouse packed again for Law Day. Our program, let me start by saying that Law Day, in 1958, President Eisenhower established Law Day as a day of national dedication to the principles of government under law. Each year on Law Day, we celebrate our commitment to the rule of law. That great commitment is enshrined in the Declaration of Independence and the United States Constitution and has been reaffirmed by the words and deeds of great Americans throughout our nation's history. With respect to Law Day, each year the American Bar Association puts out a theme, and this year's theme is Moving Toward a More Perfect Union, the Constitution in Times of Change. And we've seen some examples in recent years of how our U.S. Supreme Court applies our rights under the Bill of Rights to matters, things that weren't even imagined by the drafters of our Constitution. For example, cell phones and search and seizure law. You know, Fourth Amendment protects you from unreasonable searches by law enforcement and requires a warrant in most cases, a warrant to search. There is an exception. Incident to an arrest, an officer can search your person. If they find your cell phone, can they search the contents of that cell phone incident to an arrest? Well, the Supreme Court had to address that question, and they said that they pointed out that modern cell phones are now such a pervasive and insistent part of daily life that the proverbial visitor from Mars might conclude they were an important feature of human anatomy. So what they're getting at is that expectation of privacy. If you have your cell phone on you at the time of arrest, they can search you, they can find your cell phone, but they cannot search the contents of your cell phone without a warrant. So that headline, another modern development never imagined by the framers of our Constitution. Headline says, this is just from last year, court rules for high school cheerleader in First Amendment dispute over Snapchat profanity. Young lady was on the junior varsity cheerleader squad, tried out for the varsity cheerleader squad did not make it. While at home on a Sunday afternoon, she posted some dirty words about all that on Snapchat. Her school, her public school, punished her for that. She sued, saying she had free speech rights. She was off campus. It was on a weekend. And the Supreme Court said, yes, her free speech rights protected that act. But they also set out new rules that are going to be developed case by case. The new rules say that they can punish you for off-campus speech if it's threatening, if it's a threat to teachers and students, if it's a threat to the physical plant of the school. Those types of off-campus speech posted on social media, you can be punished for that. However, just blowing off steam, they said that this young cheerleader's Snapchat post was too remote for the school to be allowed to punish her for exercising her free speech rights. So, I know you're about to graduate, and you might wish you knew this before the end of your school, but anyhow, there we are. So our U.S. Supreme Court is having to grapple with applying principles that were drafted in the 1700s to modern technology. And that's how our Constitution is able to, or how our Constitution stands up in times of change. Our Law Day program focuses on civic responsibility and your rights. Our Law Day, Chairman Wiggins passed out voter registration applications this morning. We want to emphasize your right to vote. We'd like for you to be registered and ready to go to the polls once you turn 18. So at that point, you can exercise your right to vote. Also, we put on a real trial. It's not a mock trial. It's not an act. We have a real criminal defendant whose liberty might be at stake, and we have jurors selected from you. Let me, and that's our program, but let me recognize some people who make our program work every year. Our sheriff and his staff, the bailiffs and his deputies, Sheriff Heath Jackson. And this year we were fortunate to have a former member of our bar who is since deceased inducted into Alabama's Lawyers Hall of Fame, and that was Brooks Garrett. He has descendants that are still in the county, still practicing law. A VIP here today, Nikki T. Davis, Executive Director, Alabama Civil Justice Foundation. We'd like to thank Ms. Michelle McClung, Superintendent of the Escambia County Schools, Dr. Kenneth Varner, Superintendent, Bruton City Schools, Dale Ash of Pepsi, Webb Nall, who is a retired Pepsi employee but brings the refreshments up here every year. We can always count on him. We have our local media, Atmore News, Atmore Advance, Tri-City Ledger, and the Bruton Standard. Our county commission supports our Law Day program regularly. Our county school board, the Bruton City School Board, Jerry Aaron, the television production teacher at Flumenton High School, and our program chairman, Charles Godwin, who puts this program together and arranges for our guest speakers. And at this time, I would like to introduce our first speaker. Our first speaker is the Honorable Bradley Byrne. He's a 1972 graduate of T.R. Miller. He's a 1976 graduate of the University of Southern Mississippi. In 1979, he graduated from the University of Alabama School of Law and was admitted to the bar. He practiced law here in Brewton at Garrett, Thompson, and Hines. He was a circuit judge in Escambia County from 1987 to 2014. From 2002 to the present, he presides over our Escambia County Drug Court. He served as president of Alabama Circuit Judges Association and the Alabama Association of Drug Court Professionals. We appreciate Judge Byrne and his staff's work in this county. It's very important. They actually change lives. So at this time, would you please welcome Judge Byrne?
Thank you, Mr. Godwin, for those kind words. I do want to talk to you a little bit about our drug court program, and it's a problem that we see all too often in our county and all across our country. Drug court is kind of unique because it's a departure from the way courts normally work. It's where the district attorney and defense attorney, drug treatment specialists, and our drug court staff all work together as a team to help people who suffer from drug addiction and who are charged with a crime. That's how they get into drug court. They're charged with a crime, but the underlying root cause of their criminal activity is their drug addiction. And we've been doing that for 20 years. We were the 5th drug court in the state of Alabama, behind some of the larger circuits in the state. And I just want to say this, we have one of the best, if not the best, drug court staff in the state of Alabama. We're really blessed to have all the people that work in our program. They really care about what they do and the people they're trying to help. And we have helped a lot of people during that 20-year period. It's been very rewarding. But I just want to share with you for just a moment a few of the things that I've learned and that I've seen during my experience as a drug court judge. And one of the most troubling things that I've seen has occurred right here in this very courtroom, with people standing where I am, facing the bench, charged with a crime, and who suffer from drug addiction, or as it's more properly called today, substance use disorder. And what was troubling about that was the look of regret that I've seen on their faces. It's obvious. They regret that they've wasted some of the best years of their lives chasing a chemical. And it's really sad to see. But I know you're sitting there and you say, Judge, that's not going to happen to me. I'm not going to do that. And that's understandable, because none of them thought it would happen to them either. But it did. And what we know statistically is that 1 in 7 Americans suffer from an addiction. And we have 100,000 people die every year from drug overdose. That's like 274 people a day, which is the equivalent of, say, a passenger jet crashing every day for a whole year, 1 a day for a year. We wouldn't tolerate that, and we shouldn't tolerate deaths from drug overdose either. The famous scientist Marie Curie said, "Nothing in life is to be feared, but to be understood." And what I want all of you to understand is that continued, prolonged use of street drugs actually changes your brain. It's the greatest gift all of us have is our brains. And prolonged drug use actually changes it, and we know that from scientific research now. It changes the neural pathways, it changes the chemicals that are released in your brain, and all of that leads to a situation where a person, their primary goal in life is to get more of that drug. We also know that 90% of the people who suffer from substance use disorder begin drinking, smoking, or using before the age of 18. And one of the best predictors of drug use and possible addiction is the people you associate with. I heard a recovering drug addict tell a group of young people, "Show me your friends and I'll show you your future." And we've found that to be very true in our drug court, and that's one of the hardest things for people to do when they're in drug court and they're addicted, is to separate themselves from people that are using. So be very careful about who you associate and who your friends are. You're the author of your life story. No one can write that story but you.
And it'll be a success story if you make good decisions. The bottom line of everything I'm trying to say here today is I never want to see any of you standing in this courtroom in front of me or any other judge with that look of regret on your face. The only person who can prevent that is you. Thank you.
Thank you, Judge Byrne. Before we introduce our featured speaker for the day, I'd like to ask our bar members to introduce themselves. Go ahead, Joe.
Joe Witt, I'm a practice attorney here in Brisbane at Thompson, Garrett, Hines. With my partners Brooks Garrett, Kurt Garrett, and Ed Hines. I'm also the assistant district attorney.
Good morning. I'm Eric Cohen. I'm your district and juvenile judge.
I'm Wade Hartley. I'm a graduate of T.R. Miller High School, class of '87, and I am the public defender for Escambia County, Alabama.
Good morning. My name is Sierra White. I'm a 2011 graduate of Plumaton High School, and I practice with my dad at White & White here in Bruton.
Mike Perry, I practice here in Bruton. I have an office directly behind the courthouse, and I'm a 1974 graduate of T.R. Miller.
Jim Hart, I practice law here in Bruton, and I'm also serve as Fort Creek Public Defender. I'm a 1986 graduate of T.R. Miller.
Dan Moore, T.R. Miller, student Rebecca Ann Moore, I'm her grandfather, and I practice with the H Moore Law Firm.
Good morning, Dave Jordan. I practice here with Oxmoor.
Gordon Godwin, I have a solo practice in Atmore. I'm also the public defender for Atmore Municipal Court, and I have a son, Nolan Godwin, that attends Plumaton.
Hello, Mike Farnsworth, Assistant Public Defender for Escambia County.
Gil Ransom, Assistant Public Defender for Escambia County.
Pettis, I'm Assistant District Attorney. I'm a graduate of T.R. Miller.
Good morning, I'm Brooks Garrett. I practice law with the firm of Thompson, Garrett, and Hines with Ed Hines, my son Kurt, and Joe Witt. I'm a 1966 graduate of T.R. Miller.
Good morning, my name is Jeremy Halsey, and I have a solo practice here in Bruton, right across the street.
My name is Ed Hines, and I practice law here in Bruton, in the firm of Thompson, Garrett, and Hines.
Morning, I'm Ernie White. This is my daughter, my baby girl, and I practice law with her. I graduated from Bloomington a long time ago.
Thank you. Thank you. We have a great bar here. They're great colleagues. James H. Reid is a graduate of the University of South Alabama in 1970, the University of Alabama School of Law. He was in private practice in Fairhope, Alabama for 14 years, and in 1988 he was elected as circuit judge in Baldwin County, and he served 4 terms. He tried civil, criminal, and family court cases during his 24 years on the bench. He was elected by his judicial peers and served 17 years as presiding judge of the 28th Judicial Circuit, which is Baldwin County. He retired from the bench in 2012 and continues to serve as an active retired judge and accepts judicial assignments both in Baldwin County and statewide. He has served as a special Alabama Supreme Court justice, and he was elected the Chief Justice by his special justice peers. He was honored with the Howell T. Heflin Award in 2012, which is bestowed upon an Alabama judge or lawyer who has brought honor and integrity to the legal profession during their years of service. Since his retirement, he's maintained an active practice as a mediator, arbitrator, and private judge. He serves on the Alabama Bar Committee for Indigent Defense and is a bar representative on the Judicial Resources Allocation Commission. He's a native of Clark County. He's been married to his wife Beverly for 53 years. He has 2 children. They're both civil engineers and 4 granddaughters. He's a veteran of the United States Navy, and his hobbies are running errands and performing tasks for his wife, his children, and his grandchildren, and he enjoys traveling. Would you please welcome the Honorable James H. Reid.
Thank you, Tim. Let me just skip to that last thing that Tim mentioned, doing gardening and running errands for my wife. When I got here this morning at 8 o'clock, I got a phone call from her. I left home at 5:45 this morning. I got a phone call from her this morning saying we had a tree down in the yard, and how quickly can I get back and get that tree cut up and removed off of her flower bed. So I told her I didn't know. I don't know when I'll get home. But that's kind of how I spend a lot of my days these days. First of all, I want to thank you for having me here today to participate in this Law Day program. It's an honor to be here. More specifically, I want to thank the judges, Judge White, Judge Starnes, Judge Cole, Judge Byrne, who I served with in the Alabama Circuit Judges Association for many years. And I want to thank John Fountain, the circuit clerk. Just met John today, but I've had an ongoing relationship with John for many years because occasionally I'm assigned to hear a case here in Escambia County, and I have to email or communicate with John, and he's always so helpful and nice to take care of all of the filings that I need to do. Your district attorney, Steve Billy, the sheriff, Sheriff Jackson, the county commission. I met Mr. Raymond Wiggins. I believe he was here a few minutes ago. And of course, the president of the Escambia County Bar Association, Tim Godwin, and its members. And I want to say a special note to my former law school classmate, Charles Godwin. I understand from Tim and his brother that Charles is in Mobile today undergoing treatment for a medical problem that he's having, but I do understand that Charles is doing well and expected to recover and should be back any time now. Also want to thank all of the judges' staffs for being so courteous and kind to me when I'm here hearing a case or helping me with my filings and that sort of thing. Also, finally, I need to thank the Escambia County School Board, the superintendent, and the faculty and staff of the participating schools for being so kind as to have you here today and let you participate in Law Day. I think you'll see that this is a worthwhile exercise, and thank you for being here. And last but not least, I don't know if there are any here, but thank you to the bus drivers for getting you here today. I thank all of you for recognizing and the importance and the tradition of Law Day and your willingness to see it carried on now and through future generations. As Tim pointed out, I'm attended school in Clark County High School, which is just 68 miles northwest of here up County Highway 84 in Grove Hill. And I spent many summers here. I had first cousins who attended T.R. Miller High School, and I spent many summers here with my cousins. So I feel like I'm almost at home. As Tim pointed out, in 1958, President Dwight David Eisenhower established Law Day as a day of national dedication to the principles of government under law. In 1961, Congress designated May the 1st and the week of May the 1st as the official date for celebrating Law Day. That tradition continues on and has grown to include many countries around the world. I had the great honor to meet Margaret Thatcher, who was at one time the Prime Minister of Great Britain during the time I was on the bench. In her autobiography, Statecraft, Margaret Thatcher said that the most important, number one thing for a free society is the rule of law, and it is essential to a free country. She described the rule of law as follows: it is the form of government in which no power can be exercised except according to procedures, principles, and constraints contained in the law, and in which any citizen can find redress against any other, however powerful, and even against the officers of the state itself for any act which involves a breach of that law. Now, I'm sure all of you have heard all of the jokes that you see on the internet and you hear about jury duty. I know that some of you are going to be selected to serve on jury duty today. And three of the things that we're primarily concerned about today is the rule of law, jury service, and voting. One of the jokes is that a jury is 12 people chosen to decide who has the best lawyer. I have hearing aids, and my cell phone comes through my hearing aid, so I had to turn it down. I don't know how to turn it off. A jury is 12 people chosen to decide who has the best lawyer, or a jury is 12 people who weren't smart enough to get out of jury duty. Now, in my 24 years on the bench, I found those to be funny, but I found them not to be true at all. While good lawyering is always rewarded, juries always attempt to do essential justice, and they usually do just that. As far as trying to get out of jury duty, I found from my personal experience that most people recognize that for our system of justice to work properly, there have to be good lawyers, good judges, and good jurors. After every jury trial, and for the entire 24 years that I was on the bench, I made it my practice to go back to the jury room and debrief the jury. That is, answer any questions that they had about the case that they had just heard and about their jury service, if I could answer the questions. And it was just amazing and rewarding at the questions that were asked and the deep, deep respect that jurors have for their jury service, for the courts, and for the rule of law. While serving as presiding judge in Baldwin County, one of my duties was to impanel citizens for jury service. And I always endeavored to impress upon them that there are two functions in which every citizen should participate. One is voting, and two is jury service. Incalculable sacrifices have been made by many to ensure both of those rights. In his 1958 speech on voting rights in Washington, D.C., Martin Luther King entreated Congress as follows: "Give us the ballot, and we will no longer have to worry the federal government about our basic rights." That's how important the right to vote is. Now, what happens if you don't vote when the time comes? Thomas Jefferson once said, "We do not have government by the majority. We have government by the majority who participate." Let that sink in. Another president, Franklin Roosevelt, said, "Nobody would deprive the American people of the only way they can do that is by not voting. Next to voting is jury service. How important is it? Again, Thomas Jefferson said, "I consider trial by jury as the only anchor yet imagined by man, by which government can be held to the principles of its Constitution." And, as I am sure is well known to most of the people in this courtroom, in his closing argument to the jury, Atticus Finch said, "Our courts have our faults, as does any human institution. But in this country, our courts are the great levelers, and in our courts, all men are created equal." And I'm sure he meant to add women also. So, what do we do here today? We instill the virtues of law, the virtue of voting, and the virtue of jury service. We impress upon everyone that you do make a difference by your participation, or you make a difference by your decision not to participate. Either way, you make a decision. I want to thank you for having me here today. Enjoy the rest of the Law Day ceremonies, and thank you for having me.
At this time, I'd like to turn the program over to you and our presiding circuit judge, Judge Jeff White.
Thank you, Mr. Godwin. Ladies and gentlemen of the bar, thank you for your presence, but I need the jury box. If you will exit the stage left, please. Good morning again. All right, we're about to get started on our case. I want to go over a few things with you, introduce some people that are important to the process, our staffs and that sort of thing. Sheriff Jackson was here earlier. You may have seen the gentleman over here in the white shirt with all the gold. Sheriff Jackson wanted to be here to speak to you. However, he got called out on some type of sheriff's business. This gentleman to my right is Judge Jeffrey Todd Stearns. Judge Stearns is our other circuit judge. We had two circuit judges, myself and Judge Stearns. You met Judge Cole earlier. Judge Cole had to leave. He's our district judge. We kind of cross deputize. We kind of do a little bit of everything, whatever we have to do to make sure that all the issues are promptly addressed as best as we can. This gentleman is Mr. John Robert Fountain. Mr. Fountain is our circuit clerk. He has the monumental task of maintaining all the court files in Escambia County. He and his staff do an excellent job, and we appreciate his efforts. We have Ms. Carrie Powell. Ms. Powell, if you'll stand. Ms. Powell is the judicial assistant to Judge Stearns. We have Ms. Monica Clayton. Ms. Clayton is the judicial assistant to Judge Cole. We have Ms. Jody Wilson. Ms. Wilson is my judicial assistant. Seated down in front here is Ms. Patrice Bradley. She is our court reporter. Judge Stearns' court reporter is Ms. Denise Carley. She had to step out, I think. Oh, she's in the back. Denise, you back there? She left. She doesn't like that I make her stand, so she leaves. So we're fixing to get into our trial. We'll have the attorneys go ahead and take their place at the council tables. We'll excuse Judge Stearns and anyone else that needs to leave that has work to do. Thank you, Judge Stearns. Now, ordinarily, when we have a trial, jury trial term, we have 6 terms a year, I think. 6 or 8. 8. Mr. Fountain says 8. What we do is we'll bring what we call the jury binary. We will summons up to 300 or 400 jurors, and we'll come in, and a jury will be selected from that, what we call binary. A jury, you don't really get to pick your jury as an attorney. You get to eliminate those who you find least beneficial to your case. So we selected 14 of you to serve as jurors on this case. 2 of you will be alternates. The alternates will not go back to deliberate. They will be excused prior to the deliberations. However, nobody knows who the alternates are except me and Mr. Fountain. So all of you need to pay attention if you are named as a juror. Alternates are common because generally cases last more than a half a day and jurors get sick, family members get sick, they're unable to attend. So in a criminal case, you have to have a verdict of 12. So we usually have at least 2 alternates on all of our criminal cases. But today, we're not going to have all that more dire process. We have selected our jurors, and I'm going to ask Mr. Fountain to name those jurors. If you hear your name called, I need you to move forward expeditiously, have a seat in the jury box, go all the way down, and anything else?
You got it.
So if you hear your name called, please come forward. Mr. Fountain.
Braden Smallwood. Daisy Chavers. Dustin Carnley.
Right through here, Brad. Through the swinging doors.
Christopher Willis. Christopher Willis.
Mr. Willis here.
Reese McGill. Jayla Laster. Natalie Kramer. Jamarcus Ferguson. Jamarcus. Waylon Sanders. India Dees. John Rhodes. Antonio McCorvey. Sarah Hartley. Houston Hartley. Trent Cooper. Lexi Bassey. Anna Bishop. How many we got, John? 14.
All right, Mr. Hartley, you want to get this mic here? Yeah, it should still be working.
I'll be excused.
All right, thank you, Mr. Fountain. All right, ladies and gentlemen, at this time I'm going to administer the oath. If you'll stand for me and raise your right hand. You do solemnly swear or affirm that you will and truly try all issues joined between the defendant and the state of Alabama and render a true verdict thereon according to the law and evidence, so help you God. Do you? Okay. You may have a seat. Let the record reflect that all jurors acknowledge the oath. All right, ladies and gentlemen, this case is styled State of Alabama versus Elizabeth Cheyenne Hawthorne. And you have been introduced to the lawyers this morning, but I will go over that again. Representing the state is Mr. Joe K. Witt. Mr. Witt is an assistant district attorney. Ms. Melissa Grosso is an assistant district attorney. She's seated with Mr. Witt at the state's table. Representing the defendant, Mr. Wade Hartley, who's our public defender, and Ms. Hawthorne is seated with him at the defense table. Ms. Hawthorne has been indicted by a grand jury of this county on a 2-count indictment. The first count alleges that Ms. Hawthorne has committed the offense of unlawful possession of a controlled substance, methamphetamine. Count 2 alleges that Ms. Hawthorne has committed the offense of unlawful possession of marijuana for personal use only. Keep in mind that the indictment is not evidence. It is simply a charging document, and you should not consider it as evidence. The defendant has entered a plea of not guilty to both of those counts. You will be separated from the rest of the students during the trial. During breaks, you will remain in the jury room. There are restrooms. There will be refreshments during your break in the jury room. Listen closely. It's very important that you not talk among yourselves nor with anyone else about the case during the trial. You will not discuss the case with anyone until I tell you to begin your deliberations. In other words, when you go on break, you can't go in there and talk about what you've heard so far. That is totally improper. You can talk about graduation plans, college, but do not talk about anything that you've heard up until that point. You cannot talk about it with anyone until I tell you you can, okay? All evidence comes from the witness stand, comes from right here. You cannot do any independent research regarding anything about this case. Most of you probably have cell phones. You can't Google any terms, any names, anything on your cell phone. That is while the case is going on or during deliberations. You can't access any outside source to gain any information regarding this case. Everything comes from the witness stand. If you don't hear it from here, or if it's not an exhibit admitted into evidence, you cannot consider it. Do not investigate about this case, including anything about the alleged occurrence or persons involved. Your verdict in this case must be based solely on the evidence and the law presented during the trial. Guard against any conduct which would give anyone reason to doubt your fairness and impartiality. During the trial, there may be objections. You should not give any consideration as to how I rule on the objections. The objections are to matters of law that are not your concern. So if I sustain an objection, that's not your concern. If I overrule objection, that's not your concern. I will charge you on the law at the conclusion of the evidence, and that's the law you will apply to the evidence. We will begin with opening statements. The state will go first. They'll have an opportunity to speak to you about what they expect the evidence to show. Remember, what the lawyers say is not evidence. Again, all the evidence comes from the witness stand. They have the opportunity to speak to you, tell you what they think the evidence is going to show, but it's not evidence. Okay? After that, we'll give the defense the opportunity to make an opening statement. From that point, we'll go to the witnesses. The state will have their case in chief. The defense will then have their case in chief, and then we will get to jury charges, closing arguments, deliberations, that sort of thing. But so far, Mr. Witt, is the state satisfied with the opening charge of the court?
Yes, Your Honor.
We
Defense?
are, Your Honor.
All right. At this time, I will ask Mr. Witt, are you prepared to make your opening statement?
Yes, Your Honor.
You may proceed, sir.
Ladies and gentlemen, good morning. On March the 15th, 2021, near the intersection of J Road and Polk Road in East Brewton, Alabama, Alabama State Trooper Jeremy Elam noticed that a vehicle being driven by Joseph Hawthorne. He noticed that Joseph Hawthorne did not have a seatbelt on. That is a violation of Alabama state law to be driving without your seatbelt on. He pulls the car over. He asks the driver to come and sit with him in his car while he runs his information. Mr. Joseph Hawthorne volunteers that he had smoked some marijuana before he left his house. So Mr. Elam says, "Can I search your vehicle?" And he consented. Trooper Elam goes back to the car. He asks Miss Elizabeth Hawthorne, the defendant in this case, to step out of the vehicle. He smells marijuana on her. He asked her if she smoked any marijuana. She said no. And he then goes to read her Miranda rights. After he reads her Miranda rights, she continues to answer his questions. He asked her if she had anything in her side of the car. She said she had marijuana in her purse. He asked to search the purse. He searched the purse. He found marijuana and methamphetamine. That's what the evidence will show today. He charged her with possession of controlled substance methamphetamine and possession of marijuana in the second degree.
Thank you, Mr. Whip. Mr. Harper?
May it please the court, opposing counsel, ladies and gentlemen of the jury. Before I get started, once again, my name is Wade Hartley. You've already met me. You met my two assistants, Mike Farnsworth and Kel Ransom, when they introduced themselves earlier. But this time I want to introduce two ladies who you may see conversing with me at the table. That is, and I'll ask them to stand. That's Miss Samantha Hanks and Miss Chelsea Ferguson. Both of them are assistant in our office, and you may see them approaching our table off and on during the course of the trial. Now, you just heard the state present its opening argument in which they told you Ms. Hawthorne was charged with possession of marijuana and methamphetamine. And the suggestion from Mr. Witt and what he told you that the evidence was going to show is that this is a pretty simple case. But it's not. Y'all ever seen an advertisement for a television show or a movie, and then when you actually saw the movie or the television show, you realize the advertisement had nothing to do with it? That's kind of what this case is going to be about. Now, the state may very well be able to prove that there was methamphetamine and marijuana in her purse. They may be able to do that. I don't know. We'll have to wait and see what the evidence shows. But, you know, I don't think there's going to be a big argument about it if they're able to produce the reports that I expect them to be able to produce. That's the simple part of this case. The harder part, and what this case is going to be about, is why those drugs were in the purse in the first place. Now, your role during this course of this trial is to serve as the fact finders. The judge will determine what the law is, but you are the ones who will be determining what the facts and the evidence and the truth of this case is. You're going to hear the evidence, you're going to sift through all the facts, and then you're going to make a determination of what actually happened and why it happened. You do not serve the state, and you do not serve me. You serve the law. Your sole responsibility is to ensure justice, to hear both sides of the story, and to make an impartial and informed decision. But thus far, what the prosecution has told you and what I've told you, none of it's evidence. In fact, you can completely disregard everything Mr. Witt said, and you can completely disregard everything that I've said. Because right now, you don't have any evidence or facts before you, except for one. And what that is a presumption of innocence. When Ms. Hawthorne walked into this courthouse today, she was cloaked with a presumption of innocence. That is the foundation of our legal system, that until and unless a defendant is proven guilty beyond a reasonable doubt, they are innocent. This is a case we've got to keep an open mind. Listen to the examination of the witnesses on the stand, both the direct examination and the cross-examination. Listen to what they have to say and listen to what they don't have to say. Not guilty. That's what Ms. Hawthorne said when she first was formally charged with this. Not guilty. That's what Ms. Hawthorne said when she appeared before this court for her arraignment. Not guilty is what she's telling you today. And not guilty is what the evidence is going to show to all of us when this case is over. Thank you, and I look forward to speaking with you more during the course of this trial.
Thank you, Mr. Hartman. State ready,
Yes, Your Honor.
defense ready.
We are, yeah.
Call your first witness.
Call Jeremy Ely.
Raise your right hand for me, sir. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God? Yes, sir. Speaking to the microphone, please, your witness.
State your name for the court.
Trooper Jimmy Eagle,
Where are you employed?
with the Alabama Law Enforcement Agency,
What's your capacity with Alabama Law Enforcement Agency?
to enforce state and federal laws throughout the state of Alabama.
What's your title?
Signal trooper,
Good. How long have you been a state trooper?
approximately 4 years.
Okay. And were you on duty on March 15th, 2021?
Yes, sir.
Okay. And was that the date and incident of the incident we're here for today?
Yes, sir.
And did you happen to come in contact with Elizabeth Hawthorne that day?
Yes, sir.
And is she sitting in the courtroom?
Yes, sir.
Can you identify her?
Yes, sir.
Are you nodding towards the
Yes,
defense counsel
she's-
table? Okay. Let the record reflect that he's identified the defendant sitting next to her attorney.
It shall so reflect.
How did you, where was Ms. Hawthorne when you came in contact with her?
She was in the passenger side seat
Of,
of a 1995 F-150.
okay. Who was the driver of the vehicle?
Mr. Joseph Hawthorne.
Okay. And what was your location when you observed that vehicle?
I was coming down J Road near Polk Road.
Okay. And where was the location of the vehicle being driven by Mr. Joseph Hawthorne?
Coming off Polk Road onto J Road.
Okay. And is that in Escambia County, Alabama?
Yes, sir.
What drew your attention to the vehicle being driven by Joseph Hawthorne?
Ms. Hawthorne failed to have a safety seatbelt on.
Okay. And were you able to determine that the vehicle was his?
Yes, sir.
Did you pull him over?
Yes, sir.
Did you activate your police lights?
Yes, sir.
Did he stop?
Yes, sir, he did.
You approached the vehicle?
Yes, sir, on the driver's side.
Did you ask him anything?
I asked him to come sit in my passenger side seat.
Okay. And what's your reasoning for asking him to come sit in your vehicle?
Mr. Hawthorne showed, he was showing abnormal signs of movement inside the vehicle. I asked him out of the vehicle, asked him to come sit in, he volunteered. When he volunteered, he tried to get in the back of the police car. I asked him, I said, sir, no, you come up to my front passenger side seat. And I asked him, I said, you can sit up front. Have you ever sat in the back of one?
Judge, I'm going to object. It's testifying in the narrative, unresponsive to the question.
I sustain the objection. Ask another question, Mr.
Good. When he got in the vehicle, did he volunteer any information?
Yes, sir.
What did he volunteer?
He volunteered saying that he smoked marijuana prior to at his residence.
Had you asked him that question?
No, sir.
Did you ask him anything about marijuana?
No, sir.
Before then, had you even smelled marijuana?
No, sir.
Okay. When he volunteered that information, did you ask to search his vehicle?
Yes, sir.
Okay. And then did you get out of your vehicle to go search his vehicle?
Yes, sir.
Okay. And did you approach the passenger side?
Yes, sir, I did.
And did you ask Ms. Hawthorne to get out of her vehicle?
Yes, sir, I did.
Did you notice anything about her when she got out of the vehicle?
Yes, sir. She seemed very nervous when getting out. She showed abnormal signs of normal behavior. And at that time when she came out, I smelled odor of marijuana.
Okay. Did you ask her anything?
Yes, sir. I asked her if she smoked marijuana at her house with her husband prior. She stated she did not.
Okay. And at that point, did you read her Miranda rights?
Yes, sir, I did.
Okay. Did she acknowledge that she understood what you had read?
Yes, sir.
Okay. And did you ask her more questions, or did she volunteer information after that?
After that, I asked her if she had anything else inside that purse that was illegal. She stated that she had one joint inside of it, and then I asked her again if she had anything else in there. She did not state anything after that.
Okay. Then did you ask her if you could search her purse?
Yes, sir.
Okay. What did she say?
She didn't say anything at that time.
Did you believe at that time you had probable cause to search her purse?
Yes, sir.
Did you, what did you find when you searched her purse?
When I searched the car, I found a marijuana, grassy green light substance known as marijuana, and a crystallite white substance known as methamphetamine.
Okay. Did you place Ms. Hawthorne under arrest at that time?
Yes, sir.
Okay. Did you conduct any kind of field test on the substances in her purse?
No, sir.
What did you do with the marijuana?
I put it in a evidence bag.
Okay. When you took it out, are you trained in the identification of marijuana?
Yes, sir.
And what kind of training have you received?
Several classes throughout the training academy and then field observation of the legal substance.
Okay. Have you ever been trained at what marijuana looks like?
Yes, sir.
Have you been trained in what marijuana smells like?
Yes, sir.
Have you ever had a substance you believe to be marijuana confirmed to be so by the lab?
Yes, sir.
And when I say by the lab, do you know what I'm referring to?
Yes, sir.
And can you tell the jury what I'm referring to?
Yes, when we find a legal substance, we have to submit the evidence into submission where it is therefore transported to the lab and therefore confirmed what the substance is.
Okay. Is marijuana always sent to the lab?
Yes, sir.
Okay. Do they always test it?
In a case, yes, sir.
Have you ever testified in court about whether a substance is marijuana?
Yes, sir.
I want to show you, and you've got it here, what's been marked as marked as State's Exhibit 1.
Judge, can we stay a copy of that?
You may, sir.
Have you had an opportunity to examine that exhibit?
Yes, sir.
Okay. And can you describe what the writing is on the bag?
Yes,
Well,
sir.
what is that? Let me just explain.
This is an evidence bag used by Highway Patrol to submit drug evidence.
Okay. And can you explain to the jury what the writing is on the bag?
Yes, sir. It gives a serial number where it can be scanned into the lab, where the lab can know which item is which. It gives a case number along with the agency in possession of it, the offense, the date and time of the recovery, the subject's name, and what is description inside the bag of what the evidence is.
Okay. And have you altered that bag or its contents in any way since it's been in your possession?
No, sir.
Okay. Has it remained sealed while it's been in your possession?
Yes, sir.
Okay. And did you send it to the lab?
Yes, sir.
So you personally sent it to the lab?
Yes, sir.
Okay. And then did you receive it back from the lab?
Another trigger picked it up, or my supervisor went down, picked it up, and returned it back to our evidence locker.
Okay, and where's that evidence locker?
In Evergreen, Alabama.
And as far as you know, has it been in that evidence locker ever since it returned from the lab?
Yes, sir.
Okay, until you picked it up yesterday?
Yes, sir.
Has State's Exhibit 1 been altered in any way since you first came in contact with it?
No, sir.
Based on your education, training, experience, have you formed an opinion of whether the substance in that bag is marijuana?
Yes, sir.
And what is your opinion?
That is marijuana.
Move to amend State's Exhibit 1.
Since I'm gonna object, I don't believe it's been a proper foundation laid for the commission of marijuana.
I'm going to overrule the objection. States 1 is in evidence.
And may I publish it to the jury, Your Honor?
You may, sir. Ladies and gentlemen, publish it. You can pass it down and put it back here on this bar in front of this juror when you're finished with it.
What did you do with the methamphetamine when you found it in the purse?
Submitted into evidence, separate evidence packages, the same way I did the marijuana.
Okay. And are you trained in the identification of methamphetamine?
Yes, sir.
What is your training?
Several observations in the field, as well as training at the academy and advanced training.
Have you been trained in what it looks like?
Yes, sir.
Have you ever had a substance you believe to be methamphetamine confirmed so by the lab?
Yes, sir.
I want to show you what's going to be marked as State Exhibit 2. Showing you what's been marked State's Exhibit 2. Have you had an opportunity to examine the exhibit?
Yes, sir.
Can you tell the jury what that is?
This is a white crystallized substance known as methamphetamine.
Okay. And is it in a bag?
Yes, sir.
That's an evidence bag?
Yes, sir.
Okay. Can you describe the writing on that bag?
Yes, sir. Here shows the same, another number that it can be scanned in by the lab. It has the same case number according to the charge that she was charged with, the agency, the offense, the date and time, the name of the suspect, the victim, and the description of what was in the evidence bag.
And did you alter the bag or its contents in any way while it was in your possession?
No, sir.
And has it remained sealed while it's been in your possession?
Yes, sir.
Did you turn that evidence into the lab?
Yes, sir.
Okay. After the lab ran its test, did you receive it back?
Yes, sir.
Okay. Did you personally get it back, or did somebody else receive it?
Someone else received it and transferred it back to the evidence lab.
Okay. And as far as you know, has it remained in that evidence locker ever since?
Yes, sir.
So you picked it up yesterday?
Yes, sir.
Has State's Exhibit 2 been altered in any way since you first came in contact with it?
No, sir.
Based on your education, training, experience, have you formed an opinion as whether the substance in the case was methamphetamine?
Yes, sir.
What is your opinion?
That is a methamphetamine.
I want to show you what's marked as State's Exhibit 3. Can you tell the jury what that document is?
This document is submitted from the lab, from the evidence that was received by the lab. The lab tests it and sends us a printout of what the analysis of the substance is that we submitted to them.
Good. And what's the title of the document?
It says Drug Chemistry Certificate of Analysis.
Okay. And you're not trained on the process of how they determine whether or not that's methamphetamine?
No, sir.
That's all handled by forensic scientists?
Yes,
is
sir.
that correct? And is the methamphetamine in State's Exhibit 2 the substance that was tested by the lab and identified by that certificate of analysis, that's State's Exhibit 3.
Yes.
Can you tell by the document how that is?
Yes, sir. It states, results of analysis, says 1, methamphetamine, quotations of controlled substance.
We move to amend State's Exhibit 2, the evidence in the bag, and move to amend State's Exhibit 3.
No objection, Judge. We'll actually stipulate that report on that.
Okay. States 2 and 3, you did offer a vote, right?
Yes.
States 2 and 3 are in evidence.
I'd like to publish both to the jury.
Permission granted. Ladies and gentlemen, again, pass these around and place it back over here when you're through, after everybody's had an opportunity. Actually, Jake, you can flip through with that Exhibit 1. Do you have it?
Yes, sir.
Could you bring it back over here, please? Thank you.
Did you question Ms. Hawthorne after you read her Miranda rights? Did she volunteer any from action as whether or not the substance in her purse was hers?
Yes, sir. I asked her.
What did she say?
I do not recall what she stated at that time.
No further questions, Your Honor.
Cross-examination, Mr. Harper.
Thank you. Do you remember the first question that you were asked just a few moments ago? The very first question.
Yes, sir.
You do? What was that question?
What my name was.
And how did you respond?
I responded with my name.
So you responded, Trooper Jeremy Hill.
Yes, sir.
You telling this jury that your mom and daddy named you Trooper?
No, sir.
So is Trooper your name or your title?
My title.
So when you ask what your name is, it's not Trooper, is it?
No, sir.
Let's go back to the day of this incident. Were you engaged in any other sort of patrolling or in the course of doing anything when you observed the vehicle?
No, sir.
Did you have your lights already activated in connection with another driver at that point?
No, sir.
So what's the first thing that you saw?
I saw Mr. Hawthorne fail to have a seatbelt at the intersection of Polk Road and J Road.
So he was stopped at a stop sign?
Yes, sir.
Okay, and you were traveling at what rate of speed?
Speed limit.
Did he have a directional indicator on his vehicle? Which way was it turning?
He was turning right.
That would be coming into Bruton?
Yes, sir.
And were you coming out of Bruton or towards Bruton?
I was going away from Bruton.
Towards J?
Yes, sir.
So you met him?
Yes, sir.
How far away were you when you observed this vehicle at the intersection?
I cannot testify to the correct amount of feet. I can estimate.
That's fine, estimate.
Estimate probably 40, 50 feet.
And this was a 1995 F-150?
Yes, sir.
Ford?
Yes, sir.
What color was the vehicle?
Tank.
How many doors did it have?
2.
And it's your testimony that from 40 to 50 feet away that you saw that he did not have a seatbelt on?
Yes, sir.
$40 or 50 feet?
Yes, sir.
Is that the only infraction that you observed?
When I pulled him over for the proper call stop, no, sir, that's the only proper call stop.
Did you actually pull him over? I mean, was he in motion or stopped when you activated your lights?
He was in motion.
How far did it get?
Estimate probably not even a quarter of a mile from the stop sign.
So when you activated your lights, he immediately pulled over?
Yes, sir.
You testified that you got him out of the vehicle because he was showing abnormal signs of movement?
Yes, sir.
What's abnormal signs of movement?
Anything normal than what normal is.
Well, what's normal then?
normal is. Most people would hand you their license, their registration. Mr. Hawthorne refused to hand any of that.
Did you ask him for his license?
Yes, sir.
And he didn't hand it to you?
No, sir.
Did you ask for his registration?
Yes, sir.
Did he hand that to you?
No, sir.
Did he indicate why?
No, sir.
Now, you indicated that he did not do something. I mean, where's the motion or the movement?
He was kept to twitching, as far as twitching, meaning abnormal signs like moving inside the vehicle.
So you asked him to step back to your vehicle,
Yes, sir.
and when you got him, you said you placed him in the front seat of your vehicle,
Yes, sir.
and he just spontaneously said, "I've been smoking marijuana"?
Yes, sir.
Did you Mirandize him?
No, sir.
Did you ask him any further questions?
I asked him his general information.
Which would be what?
His name, date of birth, address.
Did you run any kind of background check through dispatch?
I ran his information, his driver's license, and his tag registration to the vehicle.
Did any sort of warrants or anything come back?
Not that I can remember.
And he told you what now? That he smoked marijuana where?
At his residence.
Did you go back to his residence?
No, sir.
You went to his truck?
Yes, sir.
Why did you ask my client, Ms. Hawthorne, to step out?
He gave me consent to search the vehicle
Why did you ask her to step out of the vehicle?
so I could conduct a search of the vehicle.
You know, you indicated earlier that you asked her to step out because she was exhibiting abnormal signs of movement. You remember giving that testimony?
That was after I smoked other marijuana.
What was her abnormal signs?
She kept fidgeting with her pants, with her arms, kept scratching her arms several times. That's abnormal from a person when they are being pulled over by the police.
So it's abnormal for people to scratch themselves and to adjust their clothing when they're pulled over by the police.
On the side of the road after it with the other marijuana. Signs of deception.
Signs of deception? She was trying to hide something?
Yes, sir.
By scratching her arms?
The illegal controlled substance that she had in the vehicle.
Let me ask you this. Were you in uniform?
Yes, sir.
Okay. Was your patrol unit marked?
Yes, sir.
Lights were flashing?
Yes, sir.
Okay. And I noticed when you came in, you got a sidearm, don't you?
Yes, sir.
You carry any kind of non-lethal protection device, like spray or something?
I do not carry spray.
Okay. You carry a baton?
No, sir.
Okay. So, but you did have a visible sidearm.
Yes, sir.
You have a badge on.
Yes, sir.
You have handcuffs.
Yes, sir.
You have a big blue flashing light.
Yes, sir.
And you don't think it would be normal to be nervous in that circumstance?
If you have nothing you've done wrong, you shouldn't be nervous.
Have you ever gotten nervous around somebody in a position of authority, even when you weren't doing something wrong?
No, sir.
You never got called to the principal's office. You never got nervous.
No, sir.
You ever got nervous when you're talking to somebody in any position of authority?
No, sir.
It's pretty admirable, really. Was Ms. Hawthorne cooperative with you?
Yes, sir.
Did you run any kind of background check on either one of them?
After Ms. Hawthorne was placed on arrest, I ran her information.
And did she come back with any kind of record?
Not that I know of, sir.
I'm sorry, go ahead.
Not that I can recall.
Subsequent to your arrest, did you do any kind of follow-up investigation or background checks? On Ms. Hawthorne?
No, sir.
Did you do any on him? On Daniel Hawthorne?
I ran
Joseph?
Yes, sir. Joseph, I ran him through the national database system.
What did that show?
If I'm not mistaken, it showed that he was a predator, prior predator over in the state of Florida.
By predator, do you mean a sex offender?
Yes, sir.
So he's a convicted felon?
If I'm not mistaken, yes, sir.
Do you know how many convictions he had?
No, sir. He does not give that.
What did the background check on Ms. Hawthorne show?
I do not remember.
Why didn't you arrest Joseph?
Because he was not in possession of the controlled substance.
So he admitted to you that he was smoking weed.
Yes, sir.
He was in possession and control and dominion of that vehicle,
Yes, sir.
but you let him go.
Yes, sir.
Now, and I might be mistaken, I stipulated to the report coming in on the methamphetamine, but I don't believe there's a report on the marijuana, is there?
Not that I know of, sir.
So your testimony was that marijuana is always sent to the lab, remember that?
Yes, sir.
And your testimony was that marijuana is always tested by the lab.
Yes, sir.
But we don't have a test on that marijuana, do we?
No, sir, not there.
You testified that you had taken classes or training in the identification of marijuana.
Yes, sir.
How many classes have you taken?
Several throughout the academy, several advanced classes throughout my career as a law enforcement officer.
Your 4-year career?
Yes, sir.
How many hours total training have you had in the identification of marijuana specifically?
I do not recall.
Where did you go to the police academy at?
Selma Wallace College.
So you went straight to the Trooper Academy?
Yes, sir.
How long was Trooper Academy?
23 weeks.
During those 23 weeks, how many days was devoted to the identification of marijuana?
Several.
Meaning, how many, give me an estimate.
Estimate at least 10 to 12 days.
So 10 to 12 days was spent solely on the identification of marijuana?
Yes, sir.
How many hours a day did you obtain that training?
Approximately 10 hours days.
So you're testifying under oath that you got 100 hours, a minimum of 100 hours of training on the identification of marijuana?
You stated estimate.
I did, and you estimated it was 10 days, at 10 hours a day, so 10 times 10 is 100, correct?
Yes, sir.
So is your testimony that you got at least 100 hours
Yes, sir.
under oath?
Yes, sir.
I noticed you got a body cam on.
Yes, sir.
Did you have it on this day?
Yes, sir.
Did you record this roadside incident?
Yes, sir.
Have you turned that over to the state?
Yes, sir.
So you asked Joseph, he said he'd smoked, correct?
Yes, sir.
But when you asked Ms. Hawthorne, she said that she had not.
Yes, sir.
She was arrested,
Yes, sir.
correct? But he was not.
Yes, sir.
Thank you. Redirect.
Was Mr. Hawthorne in possession of Miss Hawthorne's purse?
No, sir.
Was she holding her purse?
Yes, sir. She was.
You stated that you had turned the video over to the district attorney's office. You think you may be mistaken about that?
Yes, sir. I could be.
You have to turn, you have a lot of videos, do you not?
Yes, sir.
And you, most of the time, turn them over.
Yes, sir.
Okay. But they don't always get turned over, do they?
No, sir.
And we haven't, for today, we haven't asked for that video, have we?
No, sir.
So when I asked you if there was a video, you said yes.
Yes, sir.
When I asked you, have you turned over to the district attorney's office, you said yes.
Yes.
But now you made a mistake, you really didn't, did you?
Could you repeat that question?
But now, in response to Mr. Witt's question, you say, oh no, I made a mistake, I didn't turn it over.
Correct.
You don't think it would be important for you to turn the video over in a trial? When we're gonna sit here in front of this jury and we've got video evidence of one way or the other, whatever actually happened, and you don't think it's important enough to give it to the state?
What's your objection?
Argumentative.
Recognize the objection, but the question was, is it important? So I'm going to overrule it if you can answer it truthfully.
Yes.
Thank you. No further questions, Your Honor.
State. All right, sir, you may step down.
Yes, sir.
You want to keep him for potential rebuttal or
Yes.
stick around also? Any other witnesses?
No, Your Honor.
State rests at this time. All right. Any motions?
Judge, this time I'll move for judgment of acquittal.
Mr. Hartley, I'm going to let the jury go out, put them in the jury room, and we'll argue that motion outside the presence of the jury.
Yes, sir.
At this time, ladies and gentlemen, we're going to send you to the jury room. Remember what I said. Do not talk about it. Do not look at anything up on your phone. Please take them. We'll let you know when we're ready to bring you back in, okay?
All rise.
Have a seat, please. Ladies and gentlemen, it's traditional and appropriate when the jury leaves and enters to stand, so that's why the bailiff asked you to stand. Mr. Hartley had a motion.
Judge, this time I'm going to move for judgment of acquittal based on, or solely on the count of possession of unlawful possession of marijuana in the second degree. I don't think that the proper evidentiary foundation was laid or enough evidence to prove it beyond reasonable doubt. I don't think the confirmation case has been laid by the state as to that one particular count. I'll stipulate to the fact that there's enough evidence to present it to a jury in consideration of the methamphetamine, but not to the marijuana.
Okay. How do you respond?
Your Honor, the marijuana is already in evidence. She stated that she had marijuana, and Trooper Elam stated that he pulled it out of the purse. I think there's definitely a prima facie case that there was possession of marijuana in the second degree, which is possession of the purse.
The question is there evidence to address the necessary elements for, the elements are the defendant possessed marijuana, either actually or constructively, was it for personal use, and the defendant acting knowingly. Mr. Hartley, specifically, which one would you attack, or which ones would you attack?
Judge, specifically, I'm arguing that it's not marijuana.
Okay.
They've got something, but we don't have the evidence before the court to say that it's positively marijuana. We don't have a Department of Forensic Science evaluation.
Your Honor, when we have a case like this where there's multiple drugs sent to the lab, a lot of times when the lab comes back, the most dangerous drug is the one mentioned in the lab, and the marijuana is sometimes not tested.
Yeah, that's an excuse or a reason why there may not be a test. I do think that the officer testified as to the identification. Mr. Hartley can argue that qualification before the jury on the closing. So I'm going to deny your motion for judgment of acquittal, and we'll take it from there.
Yes, sir.
Where did my bailiff go? Bring the jury back in, please.
Yes, sir.
Anything else outside the presence of the jury, Judge?
No, sir.
They're coming down. Would y'all approach a moment while we're waiting for you?
All rise.
All right, y'all can have a seat. Ladies and gentlemen of the jury, we had to take up some motions outside of your presence. Those motions have been addressed. We're going to go on break until 10:45. You should have refreshments in the jury room. Again, do not discuss anything that you've heard. Do not look at your cell phones. Do not need research. Talk about anything but what you heard from that witness stand, okay? So at this time, we're going to send you back to the jury room. You will be on recess for 30 minutes. We will reconvene at 10:45, okay? So, bailiff?
All rise.
Thanks, sir, for moving that chair. Thank you. All right, ladies and gentlemen, you also are going to be on recess. I'm going to remind you that this is a working courthouse. There are people working, so as you go out the front doors where the refreshments are, compliments of Mr. Webb and Pepsi, go out the front door, remain quiet, and y'all can stay out there. I need you back in your seats at 10:45, okay? You're on recess. Let's have order. Thank you all for being back on time. Jury, please.
Yes, sir.
All rise.
Y'all got the chair figured out, don't you? You gotta move the chair when you leave and put it back when you come back. You may be seated. Thank you. All right. Bench ready to present its case in chief.
We are, Your Honor.
You may call your first witness.
Judge, please call for Elizabeth Hawthorne.
Ms. Hawthorne, right up here, please. Raise your right hand for me. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Have a seat. Speak into the microphone for me, please. Your witness, Mr. Harvey.
State your name, please.
Elizabeth Cheyenne Hawthorne,
Elizabeth, how old are you?
26,
Where do you live at?
Byrne, Alabama.
Do you work?
No, sir.
Are you married?
Yes, sir.
Now, who are you married to?
Joseph Hawthorne.
And if you don't mind telling us, what's the current status of your marriage?
We're separated.
Now, let me take you back to the day that we've all been talking about today. Who all was in that vehicle?
It was my husband Joseph, me, and my 3 kids.
And how old are your children?
At the time, they were 3, 2, and 1
And where were they located in the vehicle?
in the backseat.
Were they in child restraints?
Yes, sir.
Who was driving the vehicle?
Joseph.
Whose vehicle was it?
Joseph's.
Now, how long have y'all been married?
6 years.
And were y'all together before then?
For a little while.
At what point did you first see Trooper Elam?
When he was coming down J Road.
So he was coming toward y'all,
Yes, sir.
and your husband was driving?
Yes, sir.
Did he pull out into traffic? Did your husband pull out into?
I believe we were slowly moving out, but we hadn't we wasn't going down the road yet.
So you hadn't accelerated that much?
No, sir.
Did Trooper Elam turn around and get behind y'all?
Yes, sir.
Did your husband say anything to you when he got pulled over?
No, sir.
And do you recall the officer coming to the truck where you were sitting?
Yes, sir.
And do you recall him asking you if there was anything in your purse?
Yes, sir. He asked if there was anything in the vehicle.
And you indicated that it was in your purse?
Yes, sir.
You freely told him that?
After he asked me a few times.
Were you nervous?
Yes, sir.
Why were you nervous?
Because I knew that I was going to get in trouble.
Have you ever been in trouble before?
No, sir.
Have you ever had any kind of criminal case whatsoever?
No, sir.
Have you ever even had a traffic offense?
No, sir.
What about your husband?
Yes, sir.
Now, we heard testimony from Trooper Elam that he's actually a convicted felon.
Yes, sir. 2-time convicted felon.
Are both of those felony convictions out of the state of Florida?
Yes, sir.
Did he go to prison on those?
Yes, sir. He's done a total of 10 years in the state of Florida.
Do you know what those convictions were for?
Yes, sir.
And what were they for?
One was for a sex charge and the other was for a child neglect charge.
Now, was this before or after y'all got married?
This was before.
Is he on any sort of probation or any type of post-release supervision at this point?
No, sir.
How would you describe your life together with him?
Rough.
Has it always been that way?
For the most part, yes, sir.
And by rough, what do you mean?
What's your objection?
Relevance.
Relevance, Mr. Harvey.
Judge, we're going to pursue a defense of duress, and this is going to go directly to my client's state of mind. It's going to directly support that defense.
Overrule the objection. You may proceed.
What do you mean by rough?
He was mentally, physically, and emotionally abusive.
Okay, so he's mentally, physically, and emotionally abusive. Tell me about mental abuse. Specifically, what did he do to abuse you mentally?
Mentally, I believe it all goes together, the emotional and physical abuse. There was times that he would push me down, spit on me, call me very rude names. screwed windows and doors shut so I couldn't get in or out of my house. There were times he physically punched me, smacked me, poured drinks, threw food at me. Just anything and everything he could to tear me down.
Did you have a vehicle yourself?
No, sir.
Did you have a telephone?
No, sir.
And you testified that you didn't work?
No, sir.
Did you want to work?
Yes, sir.
Or why didn't you?
He wouldn't allow me to. My job was to stay at home and take care of our kids.
And how long did this pattern of abuse occur?
It got physical the last 2 years of our marriage.
And I know this is difficult for you to talk about. Have you taken any kind of steps in regards to this abuse?
Yes, sir. I left him and placed a restraining order on him.
And by restraining order, are you referring to the protection from abuse order?
Yes, sir.
And that was filed in the court here in Escambia County?
Yes, sir.
Have there been any, when did you file that?
I filed that in August of last year.
And since that incident, or since the filing back in August, has there been any further incidents since then?
Yes, sir. I dropped a restraining order and I tried to go back so I could have involvement with my kids, and he put his hands on me again, took my phone, and made me walk in the rain.
And did any sort of court action come out of that?
Yes, sir. I filed charges on him.
And that case is still pending now?
Yes, sir.
You have not been to trial on it yet, have you?
No, sir.
And you're the victim in that case, aren't you?
Yes, sir.
Yeah, Elizabeth, whose drugs were those?
Joseph's.
So they were your husband's
Yes, sir.
dope. Why did you have them?
Because he told me to hold them. And I was afraid that if I told him no, I was going to get hurt again.
Had he ever said anything to you about going back to prison?
Yes, sir.
Was he scared of going back to prison?
Yes, sir.
On this particular day back in March of last year, if you'd refused to put his drugs in your purse, what would have happened?
I would have gotten beat.
In connection with your protection from abuse order, did the court order the two of y'all to undergo any sort of drug test?
Yes, sir. We had to do color code, and we had to complete some other classes, and he had to do anger management.
Okay. Did you do what you were told to do?
Yes, sir.
Did you ever test positive?
No, sir.
Do you remember how many tests you took?
I couldn't tell you how many tests I took, but I know I did it for 10 months.
Elizabeth, I'm going to show you a document. That I previously marked as Defendant's Exhibit Number 2. Do you recognize this?
Yes, sir.
And what is that?
That's the PFA I filed against Joseph.
Okay, and does it include your statements at that time of what had occurred to you? Take a moment if you need to read through it.
Yes, sir.
And that's your signature on the PFA?
Yes, sir.
And those are true statements that you made?
Yes, sir.
Judge, at this time, we've moved to exhibit what's been marked as defendant's exhibit number 2.
State.
Okay.
Judge, permission to publish to the jury?
Defendant's 2 is in evidence, permission granted.
Now, when you did your drug test, you did some up here at the courthouse, didn't you?
Yes, sir. We did one in court that day.
Okay. That's the day that everything got rolling?
Yes, sir.
And then the rest of them were done through, who'd you say?
It was through, the drug court place right there, probation, I think.
Okay.
Miss Molly was the one who did my drug test.
Molly Pizzati administered those? Okay. And then I'm going to show you what's been marked as exhibit number 3. And I'm going to ask if you recognize those documents.
Yes, sir.
And what are those?
Those are from when we did our drug test in court.
And who administered those drug tests?
The judge did.
I object to this line of questions. These are not material as to whether or not she had drugs on her at the time of the arrest.
Judge, it goes to her mental state at the time of her arrest. I've already informed the court and the state's aware that we're propounding a defense of duress based on his drug use, his past felonious activity, and the fact that he was afraid of going to prison if he got caught with the drugs, so he made his wife hold him.
Yeah.
Your Honor, these were taken, these drug test results are 4 months after the incident. And they're not related to the incident and we're here to trial for.
I'm going to overrule the objection. She's already testified that she didn't test positive for several months, so I'm going to let it go in. Excuse me, he hasn't offered it. I'm going to overrule your objection to this line of questioning and allow Mr. Harvey to proceed.
So you do recognize those documents?
Yes, sir.
And does it indicate what the result of your drug test was?
Mine was negative.
Does it indicate what the result of his was?
His was positive for marijuana.
Objection, that's hearsay.
Response?
Judge, it's not being offered for the matter of the truth asserted. It's being offered, once again, to go to her state of mind. And hearsay objection is solely if it's offered for that one particular purpose. There's a litany of other reasons why it can be offered. It's simply not hearsay. It does not meet the definition thereof.
Response?
Your Honor, it's a document that is being presented and offered that Ms. Hawthorne is not even, his name is not even on the document. It's not even, I mean, it's from her husband's drug test, not hers.
Yeah, I see your point. It's an out-of-court statement. The question is it being offered to prove the fact of the matter asserted? If it is, then it's hearsay, then you have to find an exception. But if it's not being offered for the truth of the matter asserted, it's definitionally not hearsay. I'm going to overrule your objection, and here's why. She's testified to both of those things that are purportedly set forth in those documents. So I'm going to overrule your objection.
Judge, I believe if I didn't, I'm offering that as defendant's exhibit number 3.
Okay, defendant's 3, same objection states. Do you want to articulate anything else? I'm going to overrule the objection. Defendant's 3 is in evidence.
May I publish to the jury?
You may, sir. Ms. Brandon, we have our exhibits from the state's case file. Sorry.
show you another stack of documents which I've collectively identified as Defendant's Exhibit number 4. And I'm going to ask if you can identify those.
Yes, sir, these are all my results from my drug testing that I did with Ms. Molly.
And what were the results?
Negative.
Objection,
For all of them.
foundation.
Judge, we're not going into the analysis of it. I'm simply asking what the results were, which are published in a court document. Those are part of the court record in that particular case.
That, and she's already testified that she didn't test positive for that month, so I'm going to overrule your objection.
Judge, this,
To add to that objection, this is a document that was taken from November of 2021, a full 7 months after the incident. And, I mean, I'm glad she tested negative, that's great, but it doesn't affect whether or not she was possessed the drugs on the date of the incident.
We'll get her on cross-examination. My ruling stands. The objection's overruled.
Judge, at this point, we would move to introduce those as a Defendant's Exhibit, which is marked number 4.
Same objection.
Recognize, overruled. They are Defendant's 4 is in evidence.
Judge, may I publish to the jury?
You may, sir.
Elizabeth, were you scared of your husband on that day?
Yes, sir.
Are you still scared of him today?
Yes, sir.
And in fact, your fears actually came true, didn't they?
Yes, sir.
Thank you. Mr. Witt may have some questions for you.
Cross-examination, State.
Is that PFA still in place?
No, sir.
Why is PFA not in place?
I had to drop it in order to be able to see my kids.
Who has custody of your kids?
Technically, neither one, we both still have custody, but DHR placed them with him.
Okay, so DHR placed your kids with your husband,
Yes,
the one you're alleging did all this abuse.
yes.
Why did they place him with your husband?
Because he had the house, the job, and the vehicle.
And he's also a registered sex offender?
Yes, sir.
Did you know he was a registered sex offender prior to you marrying him?
Yes, sir.
And if you tested negative for, looks to be 8, 10 months, why didn't they give you custody of the children?
Judge, I'm going to object. It causes speculation on her part.
Yeah, I'm going to overrule the objection, if she can answer.
Because I did not have a place to bring my kids home to because he took my trailer.
Did you use drugs to cope with the abuse?
No, sir.
You also stated that you'd never even got as much as a traffic citation.
No, sir.
Did you not get a ticket for failure to display, or for displaying invalid insurance and obstructed windshield in Baldwin County?
On what day?
Have you never had it?
Not that I know of.
On August the 26th, 2014.
I remember that day, and it was not my vehicle. But I got a citation. It was not a ticket. It was a warning. He let me off with a warning.
Did you have to pay anything on that?
No, sir.
Why did DHR get involved with your family to begin with?
Because somebody had called in on us.
Do you know what they called?
I don't know what they called for. I know they had been out to our house previously for domestic violence.
And you don't have custody of your kids today?
Like I said, we both still have custody. We haven't went through a custody battle yet.
But you don't, DHR placed the kid with your husband?
Yes.
So your testimony here today is that DHR placed your children with a registered sex offender who abused you, or you filed for protection from abuse. You tested positive for over 10 months. Tested negative for over 10 months, but DHR still placed your kids with your husband and not with you.
Yes, sir.
Do you understand why that's hard to believe?
Yes, sir, I do, because it was hard for me to believe.
Did DHR get involved because of these charges?
No, sir.
So was DHR involved before this incident occurred?
No, sir. And actually, the same night I was arrested and went to jail, DHR was there too.
So it is because of these charges?
I guess so. That's not, I mean, when they initially came out and did the investigation, that they didn't include, that's why they were there.
What did they tell you when they initially went out and when DHR initially went out and did the investigation? What did they tell you was the reason for taking?
Hold on a second. Would y'all approach?
Did you tell Officer Elam that you had marijuana in your purse?
Yes, sir.
Did you tell Officer Elam that you had meth in your purse?
No, sir.
Did you try to Elam White was in your purse. No further questions.
Redirect, Mr. Hartman.
No, sir.
Step down. Any other witnesses, Mr. Hartman?
Judge, this time defense rest.
Defense rests. Any rebuttal?
No, Your Honor.
All right. Same motion, same argument?
Yes, sir.
We will need to take that up, same response, so that motion will be denied at this time. Okay, ladies and gentlemen, at this time we have concluded the evidence, and the counsel for the parties has the opportunity to present closing argument. Now, what you need to understand is this argument is not evidence. Remember what I told you, the evidence comes from the witness stand and the exhibits, but they do have the opportunity to argue their side of the case. The state will go first. The state has the burden of proof, so they will go first. The defense will have the opportunity to respond, and then if the state elects, they may have the opportunity to rebut or have the last word. So at this time, let me ask the state, are you prepared to present your closing argument, Mr. Witt?
Yes, Your Honor.
All right, you may present your argument.
Ladies and gentlemen, you've heard the evidence today. The charges were possession of controlled substance methamphetamine and possession of marijuana in the second degree. You heard the testimony of the trooper. He pulled the car over for the driver not having the seatbelt on. The driver just confessed that he had smoked marijuana prior to leaving the house. He gave consent to search. The trooper asked Ms. Hawthorne to step out of the vehicle so he could search the vehicle. He smelled marijuana, asked her if she'd smoked marijuana. She said no. He read her Miranda rights. She didn't have to say anything at that point. She had a right to remain silent. She continued to answer the officer's questions. She told the officer that she had marijuana in her purse. He searched the purse. He found the marijuana. You've seen the marijuana. He found the methamphetamines. You've seen the methamphetamines. You've seen the lab report saying it was methamphetamine. She continued to talk to the officer, but she never told him what you heard today was her reasoning for that being in her purse. So you got to go back to that day. You can't go back to, you got to go back to what she said that day. And she never said anything about why it was in her purse. I believe, and I would hope that you find and you unanimously vote, each and every one of you, to convict the defendant of possession of methamphetamine and possession of marijuana in the second degree.
Thank you, Mr. Witt. Mr. Hartman.
Please, the court, counsel. Ladies and gentlemen, thank you. I want to thank y'all for paying attention today. And I want to thank you for assuming the awesome role of serving as a juror in our criminal justice system. Now, I look up at the flag, and I want to tell you something. I'm proud to be an American. I'm proud to serve as an officer in this court, and I'm proud to be a part of our legal system. And we've talked about two foundations today of that legal system. The first one is the state has the awesome duty, not a little duty, but an awesome duty of proving their allegations beyond a reasonable doubt. And the second foundation that we've talked about is the fact that every defendant who walks through that door is cloaked with a presumption of innocence. Every single one. Like I told you this morning, Elizabeth is presumed to be innocent. She sits before you wearing that cloak of innocence around her shoulder. Just like I stand before y'all wearing this blue coat. Now the state has tugged, they're torn, they're ripped. They tried to pull that cloak of innocence off of her. She's still sitting there with it on. Now the judge has already told y'all what you can take back into the room when you go and deliberate. He's going to give you probably some more instructions along those lines in a few minutes. But I want to tell you something that you can always take back. You can always take this into the jury room, and that is your common sense. And what I'm going to ask you to do is use it. Evaluate your common sense. You take everything that you heard from this witness stand, and you weigh it. You put it on a set of scales, and you weigh it. And that set of scales is called your common sense. What was the evidence? You know, much of what you heard from the witness stand, I didn't even contradict. I let the methamphetamine report come in. But there are a few things that you need to consider. Y'all remember the very first question that the officer was asked? He was asked what his name was. He told y'all his name's Trooper. And then when I got him on the stand, of course, he admitted that no, his name was not Trooper. His mom and daddy didn't name him Trooper. That was just some title that he has. Just like judge, lawyer, teacher, those are titles. Those aren't our names. Now that means one of three things. Either he was confused about the question, he was confused with his answer, or he just wanted to tell them the truth. Again, in response to Mr. Witt's question, he had a video of this entire incident, and he had turned it over to the state. Actually, that was in response to my question, but then when Mr. Witt clarified it, oh yeah, I forgot, I actually didn't turn it over. Well, he was either confused about the question, he was confused about his answer, or he was not telling the truth that time either. So what I propose to you, ladies and gentlemen of the jury, you can use those things for test every word that came out of his mouth. When you consider every piece of evidence, every piece of testimony that he gave, ask yourself, was he confused about the question? Was he confused about his answer? Was he telling the truth? The video. I mean, y'all have grown up in an age of video, of things being instantaneous. Is it better to see a video or better to have somebody tell you about it? We didn't see a video today. You can also consider what you didn't see. What else didn't you see? You didn't see a report of marijuana, did you? Now, he told y'all that marijuana every single time is submitted to the Department of Forensic Sciences. He said that it's tested. Show me the test. Show me the money. Show me the test. It's not there. You don't have a test for that. Is it normal for somebody to be nervous when they're pulled over by a state trooper? Somebody comes out in their sharp-dressed uniform with a gun on their side with flashing blue lights. They don't pull you over just to have a conversation with you. You know you're probably going to be in trouble. If a student all of a sudden gets a call over the intercom, Mr. Smith, come to the office, the principal needs to see you. Well, you may not know, you may know you've done nothing wrong, but you don't want to go see that principal. You're nervous. If your mom and dad calls you and says, hey, I need to talk to you after school, you may get nervous about it. You may not have done anything wrong. It's common to get nervous when someone in authority is confronting you. You know, I told you we aren't contesting the fact that he found these things in her purse. I'm not going to argue with that. I think it's true. He found what he found. Now, I don't know if it was marijuana or not, but he found something that he thought may have been marijuana. And I'll concede the fact he found methamphetamine there. What he didn't tell you, what the state didn't bring out in their case, is why it was there. And I think I answered that question for y'all. It was there because Elizabeth was afraid of getting her butt beat, of getting assaulted by her husband, a two-time felon who's a sex offender who knew that if he got busted again with dope, he was going right back where he came from. So what does he do? He gives it to the person who has the only thing on her record is a warning for 10. A warning. Didn't even get a ticket, but got a warning. He knew he'd go back to prison. So what's he going to do? Tell her to hold the dope. And guess what? She was scared. She thought that was going to happen. And what do we know? Her fears came true. She has testified that her windows were screwed shut. She did not have a telephone. She did not have a car. She was not allowed to work. That she had been physically assaulted by her husband. That she filed to get a protection from abuse order. And yeah, she dismissed it. But why? She wanted to see her children.
Your Honor, I object. May we approach?
Sure.
And those fears came true. She was assaulted. And right now, in this very court, in about a month and a half, there's going to be a trial where her husband has to stand trial for beating her. What I've just explained to you, that scenario, her state of mind is a defense to what she did. And I expect that the judge is going to instruct you. He's going to give you several jury instructions. But I expect that based on the evidence that we presented today, he's going to give you what's called an instruction on the defense of duress. That is a recognized defense. In fact, it is a statutory defense under the laws of the state of Alabama. And basically what that says, when you break it down in layman's terms, even if you break the law, if you do that because you're either afraid of imminent death or afraid of serious physical injury, that unlawful behavior is excused. Now, we're not saying she's afraid of dying. We're saying she's afraid of getting beat. That's why the drugs were in her purse. And that is a defense to the charge of possession. And ladies and gentlemen, that's the reason she's not guilty. Thank you.
Rebuttal?
I'm going to make this quick so the judge can give y'all instructions and get back to the jury room to deliver. But what you've heard today is still the argument over the lab report. There was no lab report for the marijuana. Well, she said it was marijuana. The troopers trained in identifying marijuana. You do not need a lab report to determine whether or not substance is marijuana. They stipulated that that was meth. It was found in her purse. She did not give any explanation to the officer of why it was in her purse. We just ask you to return a verdict guilty.
Thank you, Mr. Witt.
I've got to turn the microphone back on. Sorry. Can I see you at the bench?
ladies and gentlemen, at this time, you've heard the evidence, you've heard the closing argument. I'm going to charge you to the law, as to the law that you will take back to the jury room to apply to the evidence that you've heard, okay? I need you to listen carefully and try to take in everything I'm going to try to tell you, all right? First of all, the defendant comes into court clothed in a presumption of innocence and remains innocent until the jury finds beyond a reasonable doubt the defendant guilty on one or more of those charges set forth in the indictment. Again, this indictment charges Ms. Hawthorne with the offenses of unlawful possession of methamphetamine in count 1 and unlawful possession of marijuana for personal use in count 2. Again, the indictment is not evidence, it's simply a charging document. You've heard us reference the burden of proof beyond a reasonable doubt. Let me kind of explain that to you. The burden of proving the defendant guilty rests upon the state of Alabama. The state has the burden of proving the defendant guilty beyond a reasonable doubt. In order to convict, the state must prove to each and every juror that the defendant is guilty beyond a reasonable doubt. If the state does not meet this burden of proof, then you must find the defendant not guilty. Reasonable doubt is doubt for which a reason can be given. It must be an actual doubt and not a mere guess or opinion. It is not a forced or contrived doubt. Reasonable doubt is not a mere fanciful, vague, conjectural, or speculative doubt. A reasonable doubt is a doubt of a fair-minded juror honestly seeking the truth after careful and impartial consideration of all the evidence in the case. It is a doubt which arises from all or part of the evidence or from the lack of evidence and remains after a careful consideration of the evidence. The state is not required to convince you of the defendant's guilt beyond all doubt, but beyond a reasonable doubt. Beyond a reasonable doubt does not mean that the state must prove guilt beyond every imaginable or speculative doubt or beyond all possibility of mistake, because that would be impossible. Mere suspicion or probability of guilt less than beyond a reasonable doubt is insufficient. As to the charge of unlawful possession of a controlled substance, the defendant is charged with unlawful possession of methamphetamine, which is a controlled substance. A person commits the crime of unlawful possession of a controlled substance if he, in this case she, possesses a controlled substance. To convict, the state must prove beyond a reasonable doubt each of the following elements of unlawful possession of a controlled substance. That the defendant, Elizabeth Cheyenne Hawthorne, did possess a controlled substance, namely methamphetamine, and that the defendant acted knowingly. A person acts knowingly with intent to conduct or to a circumstance when he or she is aware that his or her conduct is of that nature or that circumstance exists. If you find from the evidence that the state has proved beyond a reasonable doubt each of the above elements of unlawful possession of a controlled substance as charged, then you shall find the defendant guilty of unlawful possession of a controlled substance. If you find that the state has failed to prove beyond a reasonable doubt any one or more of the elements of the offense of unlawful possession of a controlled substance, then you cannot find the defendant guilty of unlawful possession of a controlled substance. Unlawful possession of marijuana in the second degree. A person commits the crime of unlawful possession of marijuana in the second degree if she possesses marijuana for personal use only. To convict, the state must prove beyond a reasonable doubt each of the following elements of unlawful possession of marijuana in the second degree. That the defendant, Elizabeth Cheyenne Hawthorne, did possess marijuana, that she did so for her personal use only, and that the defendant acted knowingly. Again, knowingly is defined as a person acts knowingly with respect to conduct or to a circumstance when he or she is aware that his or her conduct is of that nature or that circumstance exists. If you find from the evidence that the state has proved beyond a reasonable doubt the offense of unlawful possession of marijuana in the second degree as charged, you shall find the defendant guilty of unlawful possession of marijuana in the second degree. If you find that the state has failed to prove beyond a reasonable doubt any one or more of the elements of unlawful possession of marijuana in the second degree, then you cannot find the defendant guilty of unlawful possession of marijuana in the second degree. There are two types of possession, actual and constructive possession. Actual possession is when the contraband or drugs are found in the person's actual possession. Constructive possession is if it's relied upon, prosecution must prove beyond a reasonable doubt that the accused had knowledge of the presence of the controlled substance. This knowledge may be inferred from the accused's exclusive possession, ownership, and control of the premises. When the accused is not in exclusive possession, knowledge may not be inferred unless there are other circumstances tending to buttress this inference. A non-exclusive list of circumstances that may establish a connection between a defendant and a drug contraband discovered when the defendant is not in exclusive possession of certain premises are evidence that excludes all other possible evidence, evidence of actual possession, evidence that the defendant had substantial control over the particular place where the contraband was found, admissions of the defendant that provide the necessary connection, which includes both verbal admissions and conduct that evidences a consciousness of guilt when the defendant is confronted with the possibility that illicit drugs would be found, evidence that debris of the contraband was found on the defendant's person or within her personal effects, evidence which shows that the defendant at the time of the arrest had either used the contraband very shortly before or was under the influence. Constructive possession exists when the defendant exercises or has the power to exercise dominion and control over an item. I charge you members of the jury that it is a defense to prosecution if the defendant engages in the prohibited activity because she was compelled to do so by threat of imminent death or by threat of serious physical harm to herself or another. Now we have multiple counts, okay? So you've heard me tell you what the elements are for unlawful possession of a controlled substance, unlawful possession of marijuana in the second degree. You have to address each count individually and apply the law to the evidence regarding each count. You must reach a verdict on each count in the indictment. You must consider the evidence as to each count separately and determine whether the defendant has been proved guilty of the offense charged in each count beyond a reasonable doubt. I'm getting ready to release you to the jury room. I want to tell you some of the process. The first thing you should do when you get back there is select a foreperson to lead your deliberations. Understand that the foreperson is not in charge, does not make directions. The foreperson facilitates the deliberations, okay? You're all equal in the jury room. The foreperson just kind of manages the conversation. You will be given the possible verdict forms. When you have reached a verdict, the foreperson must complete the appropriate verdict form and then sign the form. The verdict must be unanimous. That means that all 12 of you must agree on the verdict. The verdict must be unanimous. That means that all 12 of you must agree on the verdict. When you have reached a verdict and completed the form, you notify the court attendant who will be waiting outside by knocking on the door. We will then return to court to receive your verdict. It will be necessary for you to come back into the courtroom to receive the verdict. If you have a question regarding the law that I've talked to you about or anything, you knock on the door, you need to write your question down. Ms. Wilson, we need to make sure there's writing utensils and a pad. If you have a question, You can write that question down, knock on the door, give it to the bailiff will deliver it to the court, I will give it to the attorneys, and we will determine what action to take, if any, okay? The verdict forms. These are the verdict forms. I'm going to read them to you. Please take nothing from the order in which I read them. I just got a stack, and I'm going to read them the way they're stacked, okay? The first verdict form says, we, the jury, find the defendant not guilty of unlawful possession of a controlled substance. Bottom right-hand corner, print 4 persons' name, 4 persons' signature. Once you have reached a verdict, if this is your verdict, you would sign this form, okay? The next form is, we find the defendant guilty of unlawful possession of a controlled substance. 4 persons' printed name, 4 persons' signature. If this is your verdict, this is the form to return. The next form is, we, the jury, find the defendant not guilty of unlawful possession of marijuana in the 2nd degree. Print 4 persons' name, 4 persons' signature. If this is your verdict, this is the verdict form you will return. The last one is, we, the jury, find the defendant guilty of unlawful possession of marijuana in the 2nd degree. Again, 4 persons' printed name, 4 persons' signature. All right? If that is your verdict, you would return that verdict form signed by the 4th person. That covers everything. I'm going to send you back to the jury room. Again, don't say a word about the case until I deliver the forms to you through the bailiff and instruct you to begin deliberations. You don't talk about anything until I tell you to start, okay? So at this time, we're going to recognize our alternates. Our alternates will remain seated, and everybody else will be excused to the jury room, okay? Our alternates are Natalie Creamer and John Rhodes. Ms. Creamer, Mr. Rhodes, let me see who you are. Okay, you all will remain seated, and you will not go back to deliberate because you were alternates, okay? So at this time, Jacob, if you would take the jury to the jury room and take up some issues with the lawyers. But wait, one more thing I need to say. Sorry. I'm going to send these exhibits back to the jury room for you to review, okay? Now listen, these sealed exhibit bags better be sealed when I get them back. Do not open these bags, okay? That is totally inappropriate. Take them back there. When you come back in with your verdict, you will bring all the exhibits back with you. We will turn them over to our court reporter for safekeeping, okay? I will send the verdict forms and the exhibits back when I'm ready for you to begin deliberations. Now you can go.
All rise.
Ms. Creamer, Ms. Rose, y'all can have a seat. Y'all can all have a seat. At this time, I'm going to ask counsel if they're satisfied with the court's oral charge. Stay satisfied. At this time, we're going to turn this over to the Honorable James Eric Cole. He's going to have a discussion with you. We're going to ask Ms. Wilson to deliver the verdict forms and the exhibits to the jury and tell them they may begin their deliberations, okay?
Thank you, Your Honor.
Thank you, Judge.
Good morning, everybody. Judge White, I'm Judge Cole. I introduced myself earlier this morning. I get the fun part of the program. I get to talk to y'all about what happened today, okay? First off, I want to congratulate all y'all on your pending graduation. I hope you do well in life. We had a speaker yesterday. He didn't speak today, but one of the things he says, you can make life easier, you can make life harder, okay? And it depends on the choices that you make. I believe Judge Byrne talked about also about the friends that you associate. So be careful what choices you make and the friends you associate with. So we hope you do well. I want to thank the lawyers, Mr. Hartley, Mr. Witt. I know Ms. Grosso, she participated yesterday, so she didn't have a big role today. Mr. Ransom, Mr. Farnsworth with the Public Defender's Office. We appreciate what they do. Officer Elam, appreciate him taking time today to be with us and testify. One of these trials, to me, as I used to prosecute some, these are more stressful than having other trials, to me. We got a courtroom full of people, and these attorneys are on display, so it makes a little bit more pressure for them. So, but we appreciate what they do. And Judge White, appreciate you presiding today and yesterday. Judge White does a great job, so we appreciate him doing what he does. First off, I'm going to ask the alternates, I'm going to put them on the spot. As far as possession of methamphetamine, what's y'all's verdict? Have you had a chance to think about it? What would you say? Not really. So do you have an opinion one way or the other, which way you might have went on it? Ms. Kramer, what about you? No? What about marijuana? So y'all don't have an opinion one way or the other? Okay. All right. Let me ask y'all, who thinks they're guilty of possession of methamphetamine? Got a few hands, not a lot. All right, who's my not guilties? Not guilty. Okay. All right, what about marijuana? Guilty. Okay. All right, not guilty. Okay, it looks like it's more not guilties than guilty today. Mr. Hartley, that may be a good sign for you.
Can I take the rest of the day off?
Yeah. One thing I want to talk to you about is your summoned for being a juror, okay? There's a misconception about how you're summoned to be a juror, okay? It's not by whether you register to vote or not. It's by your driver's license. So if you get an opportunity to register to vote, please do it. I mean, I don't want to go up there to the courthouse and waste my time serving as a juror. Don't take that attitude, okay? You got to think, if you were on trial, who do you want to be be that 12 looking out for you? You won't. Now, most of y'all young children are 18 roughly. Who do you want on that jury? Do you want some 18-year-olds on there, or do you want some 55-year-old men like myself? You got to think about this. So, if you get an opportunity to serve, please do it, okay? We kind of streamlined the process today as far as selection of a jury. Normally how a jury is selected, we'd have a crowd roughly this size. The attorneys would be up here and they'd ask you questions about certain things, where you work, where you live, who you married to, what they do. There'd be a lot of questions asked to determine whether or not they want you on the jury or not. And then we would strike from a panel and get 12 to be up there, okay? So it was a little bit different today. How did y'all like the trial? Anybody want to say what they liked or didn't like about it? Any hands? What do you like or dislike about the trial?
I liked how
Go ahead.
I liked how that not only did they present they presented possession, yes, but it also showed that records worked with weed, like marijuana. We saw that there was marijuana, but then Byrne, of course, that's the thing, and also that we put in background as the scenario, because as they said, we don't know why, but we know we only had possession.
Okay. All right. Thank you. Anybody else want to say what they liked or disliked about it? We got a hand over here.
I like how she said my trailer was funny.
All right. Let's do this, okay? First thing we want to talk about, you guarantees as American people what our freedoms are. And Mr. Hartley spoke about one of them. What do we have when we come in the courthouse if we've been charged with a crime? We've got a presumption of innocence, is that correct? So we're not already guilty before we come up here and come before the judge and be sentenced. So we have a presumption of innocence, okay? What else did we talk about? Or what other freedoms do we have? We talked a little bit about you have a right to a public trial, okay? You do have a right to have a public. You come in here, and everybody's here, and we get to talk about everything in front of us. It's a public process, okay? Ms. Hawthorne had a right to have an attorney. Mr. Hartley's office was appointed to represent her, okay? So she has a right to have an attorney to defend her. Okay, what did Mr. Hartley have an opportunity to do with Trooper Elam? He had an opportunity to cross-examine and question Trooper Elam, okay? So you have a right to confront your witnesses. Anybody that's testifying against you, you have a right to confront, okay? How many people we have over here that's going out deliberating now? Got 12 people. So you got a right to have a trial by jury. So you have certain constitutional rights guaranteed to you, okay? So let's, so we deal with that. Mr. Hartley and Mr. Witt's here. Now, one thing I want to do, like I say, this is the fun part because y'all get an opportunity to ask some questions, okay? Whether it be from me or to defense counsel or the prosecutor, okay? So who wants to ask a question? Don't be bashful. You're not 12 flower pots sitting up in here, okay? Anybody got questions? Yesterday, I had a bunch of them now. They showed out yesterday. Now, we had Atmore here yesterday, Atmore Christian. I mean, not Atmore Christian, but EA. Golly. Y'all be quiet now. Okay. All right, go ahead. Go ahead. Let's kind of stay away from that. There's a lot of factors that go on that we don't know about, that we didn't hear from the witness stand. So DHR wasn't here to testify, so we don't know exactly what the thought process was. So let's kind of stay away from that question. And it's probably a lot of people want to know why, I hope so. But anyway, let's stay away from that question. Let's talk about the trial, okay? Anybody got any question for Mr. Hartley? Okay, we got a question back here. Yes, ma'am.
So why was the driver who had admitted to smoking marijuana not arrested? Yes.
I'm gonna let Mr. Witt I'm gonna let them answer that
I want
question.
you as my co-counsel next time.
So just admitting to having smoked marijuana is not a crime. They did not find any marijuana on him, and it was in her purse, so that's why she was charged.
And the officer actually could have, I mean, it's within the officer's discretion because the argument could be made that there was constructive possession on his part as well. He was in control of that vehicle. It's something that y'all need to understand, and I'm sure Trooper Elam can tell you. If you're driving a vehicle, there's another legal presumption that you all need to know about. If you're the driver and operator of a vehicle, you're presumed to have knowledge and control over anything in it. So, you know, the next time you give a ride to 2 or 3 of your friends, you might want to ask them what they got in their pocket. Ask them what they're holding. Because you can be charged with that as well. Or if you jump into a car with one of your buddies, they got a duffel bag full of dope in the trunk, good chance both of you go into jail.
I had a hand up over here. You got a question? Okay, we got a hand. Let me get this young lady over here. Y'all got to keep it down now. We got to.
He said that the dude admitted to smoking at his house before he got in the car, so why didn't they go back to his house and try to look for evidence of that?
Trooper, you want to answer that? Hold on.
He would have had, that would have been up to the officer to try to go get a search warrant. He couldn't just go back and check the house.
All right.
Without a search warrant.
Let me get this lady right here.
Not only was he under the influence, he didn't have any type of identification
there wasn't any evidence that he was driving under the influence. What evidence, why did he stop him? Seatbelt, but he didn't say he was driving all over the road or he appeared when he got out of the, you didn't hear that, okay? Hold on, y'all gotta keep it down. Keep it down. Officer Elam's gonna answer that last question, is that right, Mr. Officer?
Certain series of indications that lead up to the questionable of impairment driving. You've got what they're doing, what signs do they have? Is their eyes dilated different ways? Are they slurred at speech? Marijuana causes that. Have they smoked multiple times? Are they addicted to it? Just as well as as adults taking as prescription medication, therefore they become immune to that drug more, right? Say somebody takes too much Benadryl with something else. That includes impairment, but is it enough to drive? You have to have a series of tests that is demonstrated to him. He showed no signs of impairment when driving. I could not smell the proper cause, which is odor of marijuana on him, right? You got to have proper cause in order to do that, right? He had no slur at speech. He had no abnormal signs other than being super, super nervous when encountering Mr. Joseph. Any other questions?
Thank you, Trooper. Yes, sir. Hold on. Go ahead.
So, is your trooper car not equipped with a roadside drug test? Because if he admitted to smoking it, should you not have checked first? If it's not equipped, your car is equipped with drug tests for these drugs, but your car is not equipped with a actual drug test?
No, that's what, so when somebody's driving impaired, it has to be a series of tests. We have what you call standard field sobriety tests that we have to run you through. It's a series of small tests that shows us indicators of whether you've been impaired at whatever you're taking at that time, along with the totality of the circumstances with the whole traffic stop from the time I encounter you. Drug tests can only be done by a drawing of blood in order to tell what's inside the systems. We do not have indicators that tell that that's why we have standard field sobriety tests.
Okay, but see, from the field sobriety test, there are plenty of people that can be under that influence and do it better than if they were sober.
Go ahead, Trooper, if you want to answer that.
Oh, that
he has to make a judgment call. That's the thing about it. He has to make a judgment call out there on the road whether or not somebody's driving under the influence. Basically, on his arrest, he didn't have enough probable cause. Like I said, the guy wasn't going all over the road. He wasn't staggering when he got him out of the vehicle. I assume he doesn't do anything that would cause you any wrong. So he has to make a judgment call. Yes, ma'am.
With the issue of the body cam, this might be for the lawyers, was that never going to be brought into evidence? Was it misplaced or?
If we would have had a full-blown trial, there would have been a lot of other witnesses involved, and that would have been fleshed out before we got here today.
Judge, can I get these two jurors back to the classmates? Y'all can come on down. I'm sorry, you can, I want you to speak up there a moment.
These seats are more comfortable.
Yeah, that's true. Those seats are more comfortable in these pews. I think I had some over here. Yes, ma'am.
So when he was pulled over, he kind of talked to the cop and he said, I was at my house and I was smoking. So he was under the influence while driving. And even though he didn't show his license or registration to said vehicle, he was in the driver's seat of said vehicle. So that should mean that whatever is in the vehicle should be on him, not on her, because it wasn't on her physical body. May have been in her purse. Yes. Did he put it in there?
So you're saying he should have been charged with driving under the influence?
He should have been charged with driving.
You got the part of the law of driving under the influence is physically unable to control a motor vehicle, unable to drive a motor vehicle. Evidently, he can still drive. So the trooper made a call not to charge him. All right, go ahead. Child endangerment, trooper. With the kids in. How come you didn't charge them with child endangerment?
Child endangerment,
Yeah.
due to the lack of knowledge of them, of him being impaired, then I can go further if I needed to with the standard field sobriety. But
that the kids were not at harm at any time during the traffic stop or in encounter with them.
Yes, ma'am.
With y'all finding drugs in her purse, wouldn't that still be classified as child endangerment because there's drugs by the kids?
I'm not very familiar with that law as far as.
Hold on, let me see, I got this. Yes, sir. Y'all be quiet.
If the driver was there a significant part of this case, why was he not relevant to the witness stand in this case?
He wanted to know why the driver was called in the witness.
Probably because he's got two convictions on his record, and I would have impeached him immediately.
He probably wouldn't have been a credible witness after Mr. Hartley or whoever he testified favorably would have cross-examined him and brought up his convictions. Okay? Yes, ma'am.
Okay. Okay, so the officer said, correct me if I heard you wrong because it's hard to read back here, but the officer said that driving under the influence is when you can no longer control the motor vehicle. Is that right? Is that what he said?
Safely operate a motor vehicle.
Okay, so the dude admitted that he had smoked before driving. You're gonna wait for something severe to happen and people to get hurt before you condemn the person that literally admitted that he was under the influence while driving.
I don't think he admitted to being. I don't think he admitted to being under the influence. I think he admitted to smoking marijuana.
Judge Cole, we have a verdict.
Okay, all right. Good luck to everybody. Thank y'all. Appreciate it. All right.
All right, have a seat, everybody. The jury reached the verdict. Foreperson is Mr. Hartley. Okay, if you'll deliver the verdict forms to the bailiff, please. We ask the foreperson, are these verdicts, the verdicts of the jury? And are they unanimous? Okay, would the defendant rise? Right. The verdicts are as follows. We, the jury, find the defendant not guilty of unlawful possession of a controlled substance. We, the jury, find the defendant not guilty of unlawful possession of marijuana in the second degree. Is that your verdict? All right, anything from the defense?
No, sir.
From the state?
That's going to be polled.
This is, the state has asked that the jury be polled. You remember when I swore you in that it had to be unanimous verdict, so at this time we'll start with Mr. Hartley. Is that your verdict?
Yes.
Sir, what's your name?
Antonio McCourt.
Mr. McCourt, is that your verdict?
Yes, sir.
Sir, what's your name?
Jim Cooper.
Mr. Cooper, is that your verdict?
Yes, sir.
Ma'am, what's your name? Sarah, is that your verdict?
Yes, sir.
Okay. Ma'am, what's your name?
Miss
Ms. Basie, is that your verdict?
Yes, sir.
Sir, on the end, what's your name?
Waylon Sanders.
Mr. Sanders, is that your verdict?
Yes, sir.
Ma'am, what's your name? And is that your verdict, Ms. Bishop?
Yes, sir.
Your name, ma'am?
Easy D.
Ms. Dees, is that your verdict?
Yes, sir.
What's your name, ma'am?
Ms. Chambers, yes, sir.
Ms. Chambers, is that your verdict?
Yes.
Sir, what's your name?
Dustin Carmen.
Mr. Conley, is that your verdict?
Yes, sir.
Sir?
Reese McGill.
Mr. McGill, is that your verdict?
Yes, sir.
Ma'am?
Raven's following.
Is that your verdict?
Yes, sir.
All right, poll the jurors, the verdict is unanimous. Anything else from the state,
No, Your Honor.
from the defense? All right, ladies and gentlemen, that includes the trial, that includes the law day. Ms. Hawthorne will be discharged on these charges. Appreciate your attention today, the way you acted, we appreciate it. I hope you've learned something. Thanks to Ms. Hawthorne, thanks to the lawyers, my personal thanks. I know it's a lot of work, I've been on both sides. So without further ado, you are hereby released. Good luck to all of you.